Ghana Beyere Supreme Court Ediom ruling aba. Na obi asemu a work na say, you see, eyana ye the constitution issue ekokoto Supreme Court anymore. Eye for interpretation. Into normally no say Supreme Court's Emma ruling area. Omo wiepe e was say obia akuma tone yem because they will interpret it better for us all to understand. But we have sa afenyoma in case here what they call to Supreme Court ruling ne ba no. Afe ya mo obia ye confused rather. Into obia some work can say asem no answer na be ko Supreme Court kra na ne eti ase. E ko Supreme Court ba na afe Ghana for confused. Lawyers and every single person are confused. Into obia aka ne de NPP for nam say ya kan momo NDC for so say Supreme Court ruling ya be there and kan ma NPP for it is say obi enim. Now the person at the center of this Alban Bagbin ono ankasa ne lawyer our representing the court Titus sorry Eden Krat aba betuja. Now one also read the Supreme Court ruling no na ono ne nti ase a wo ka tre Alban Bagbin and they say there is no order against the speaker. Or say a ruling when a Supreme Court e dia ba na ruling when a Supreme Court ejina so dia. Now there's a Supreme Court ruling no mo dia ba no enye ohye bia wo mo dey to speaker so. Enti speaker no decision bia we take bia no ebetumi stand saa eni kwan say Supreme Court for no etumi she speaker no because ruling no mo dey aba na enye ohye no mo dey to speaker no so speaker no betumi ayede ope basically no em say ono so dey work no na nsem a wode to social media no me baba be kenkan based on ono so ni understanding me say saa same way won as a lot of people thought that the Supreme Court will bring finality to this issue. Now more confusion because Alban Bagbin the lawyer no ono so n'entri ase a wode be ma Alban Bagbin no yenkenkan. I say the Supreme Court decision released this afternoon is interesting. Into ti ono so asem wo kan Supreme Court decision na aba no wadwen we say sade we die. I say it is interesting. The majority decision raises a number of legal issues. Since this is a public and not legal platform, I will discuss the most basic but fundamental issue for debate. So I say, onim say, enye court, into obe breaking it down na Ghana for ye kinkai no, obi aye den atiase. On say yana, sometimes court in sense no too complex or mo bro for your complex, ma ye in quote yenye leled no. I say in every case before the court, the court's final judgment is based on the case presented to the court contained in the original papers filed by the plaintiff before the court. If the fact on which the plaintiff initially presented their case to the court changes and they want the court's decision to reflect the changed circumstances, they must formally change their original case by way of an amendment. The Supreme Court rules allow the plaintiff to amend their statement of case. Or say, Ghana has say no, court case biano. Eye based on nipa krona wode asem ne ba ne nsem a wo ye den wode ba court ema ho kwan na nipa krona asem a wode ba na no ne ye beka ho asem iti court ema ho kwan se nipa krona wode asem ne ba no obetumi aka kire court say asem we ya medi nkan a mede ba ye no me pese me sesa because menya new information e wo ho court ema sa ade no ho kwan nti no original nipa kuni case a wo file ye no sa case no ehun ruling na was a Supreme Court ye den edeba yemfa ne say wakwa wi obi ade na nipa ko na wakwa wi ana ade no o de akọ court se wakwa wi ne 1 cedi na ebia na enye 1 cedi pe na wi a 1 cedi usanso wi ana akọkọ wi ana emu e kan ho but o de court no o de court court nim say eye 1 cedi na nipa ko na wi a court na asem a wo kan no eye 1 cedi na nipa ko na wi a no ho asem na wo kọ akọka on kan say 1 cedi na wi a ne ka ko wi a emu kan ho da bi enye sa asem na nipa ko ndi aba court plaintiff no or the ba say we wi a me 1 cedi nti no na court na wo say ohwe na wo kan ba court man nipa ko ne kwan say embra ye kan 1 cedi ne ho asem no wa obetumi asanso aba say hey na ye me say 1 cedi pe no wi a ye sisi anu me hu ni say wasanso wi a ma akokọ aka ho court ma ho kwan say wo say wo yes a ati ase nti wo hwe a afenyoma kin case na wo de ba ye no wansesa. Anyway, yento aso. I say now that the majority judgment unequivocally admits that the time the plaintiff filed his case, the speaker's response to the statements made by the leader of the NDC caucus in parliament had not been made. Dakwa Asari, JSC, admits that the plaintiff instituted his action on 15th 2024, and the speaker made his statement on 17th 2024. The plaintiff's reliefs, therefore, did not pray the Supreme Court to declare the speaker's response to the statement null and void. Darko Asare, JSC, therefore conceded in page 4, see especially paragraph 4 of his judgment, that on the fact on which the plaintiff instituted the action before the court, there was no issue on which the Supreme Court's exclusive original jurisdiction was legitimately be invoked. And this is quite interesting. Utia, or say Supreme Court decision now omodia banekrano. There is an admission. Now admission they say speaker no response to the statements NDC caucus leader no emeki ye no. Judge no admit say the plaintiff were afenyo marking no at the issue ne ba court 15th on 15th. And the Speaker of Parliament is making a statement on 17th. Now the same afenyo marking the issue ne kra ba ye no. Alban Bagbin, that time no nya make statement bia Parliament. It is that time afenyo marking the release court na war ban war back court the assembly back court no. Reliefs are what they buy no. And can't court no afenyo marking and man be can't court ne say yen declare Alban Bagbin ne response to the statement as null and void. Afenyo marking case na what they buy court no. Case na nka say Alban Bagbin nsem a waka no mumbongu. Afenyo marking ne sa asem no de buy. Ena we Alban Bagbin ne lawyer waka say based on the judgment no. Judge no admit it. Say enya sa case na afenyo marking de buy. Wan fa mba say yembo Alban Bagbin nsem engu. Just as I'm telling you, nipa kono si we akoko 1 cedi. O court say we 1 cedi a, o de be ko say 1 cedi na we nti. Ebia, moma onfa mesika ma me biom. Ana say 1 cedi na we nti. Moma yenchi ni ntum. Afenyo ma keneba no, wamba meka say Alban Bagbin nsem a wo ka no, enye nti yembongu. Eno say judge no edge to mu in page 4, especially paragraph 4. Say the fact on which afenyo marking the issue no eba court no fact na afenyo marking indigenous or the issue no eba court no, there was no issue on which the Supreme Court's exclusive original jurisdiction was legitimately be invoked. Fact na afenyo marking gina so a the bar court no enya nsem we was say ye gina so say ye de nsem no eba Supreme Court. Judge no admit e wo ne nsem ni mu ne judgment mu. Also, Darko Asare, JSC, also admitted that it is events after the plaintiff instituted the action in the Supreme Court that was of concern to the majority. The plaintiff, however, did not formally, by way of an amendment of his case, formally bring the new facts to the court as part of the substantive case before the court. Until most of the issues are abaninano. After afenyo marking edi asem no call court intinanka ade anka was afenyo marking ye ne say e was all call back to the Supreme Court no ka say enyama bebresi me ba court e ba wie ye no esisi a fact no bebresi e bi ne say sisi a NDC majority speaker aka asem say ti me pesa me sesa issues no na me di new facts no den eba but afenyo marking did not amend the facts are what they bar court, and this is the judge admitting. So see, the new facts came to the Supreme Court by way of an interlocutory ex parte application, and the court dealt with it. The substantive case, however, remained the same. It's a new fact na afenyo marking the buy no interlocutory ex parte na what they buy no, and no the new facts ni shemu, but the substantive case the old issue no, and no. It remained the same. Afenyo marking and sesan bibia. It was said that Darko Asare JSC therefore admitted that it is subsequent events occurring 2 days after the issuance of the writs, which is the speaker's statement that the affected MPs cannot be allowed by law to continue to pretend to be representing their constituents, and Parliament was accordingly so informed that that constituted the act that caused the Supreme Court to stay execution of the Speaker's said statements pending the determination of the matter by the Supreme Court. See page 5 of this judgment. I don't know whether at this point you understand. Once I answer na afenyuma ken bekwa koye sa interlocutory expert no. Or yes or okosiki injunction. It is an injunction now what they call court no. That is the main issue. But that time no the injunction no. Or yes okosiki injunction no. That time no. Na enyama ebesi ebeye Alban Bagbin the declaration of the 3 MPP seats and the 1 NDC seat vacant no na enyensi ye. But the nanka was afenyuma kenye ne say nanka was okoko sesan the fact but one sesan omane ka ho. Now see, the court however justifies its decision to assume jurisdiction in respect of the Speaker's subsequent response to the leader's statement on the ground that the decision had an intimate connection with their jurisdiction and its inextricable link to the pleaded facts and issues. Also, Dakwa Asari JSC, who wrote the lead judgment of the court, therefore clearly admitted that there was no cause of action on which the plaintiff sought and obtained the order for stay of execution. The effect of this admission also is that at all times material to the judgment of the court, the plaintiff's case before the court disclosed no cause of action because the case was not formally amended to reflect the changed circumstances. It is acknowledging that this admission meant the certain petition of the plaintiff's case before the court that the majority decision had to take cognizance of a case that was not formally brought before it to enable it entertain the plaintiff before the court. I know say it sounds a bit confusing, but stay with me. Into someone Alban Bagbin, a lawyer can say judge no clearly no in the judgment no admit say afenyuma kin case award by there was no cause of action. Afenyuma kin case award by no cause of action bi anka ho. Na afenyuma kin ehwe say enu hunti yemfa ma eye stay of execution. Now Alban Bagbin lawyer say judge no ayesa admission we are not say in effect no the effect of this admission say at embre bia no the judgment of the court, the plaintiff's case before the court no case na ebabeto court ni nim no any cause of action bia because the case was not formally amended. Ya amend the case ninti any cause of action bia no na kai was a reflect afenyuma ken kokoye na ade no reflect events saying the change circumstances. I'm going to explain Mr. Mo metre say no biati ase. Inti basically no the can say afenyuma ken the case aba. Ba case afenyuma ken the ba no any engina so bia and then you find the cause of action. There was no cause of action. Afenyuma ken ebe siki stay of execution no. On say law no wo de asemi ko court a wo say onye engina so bia wo de pe bibi. Engina so me de pe ade yi eni. It afenyuma ken ade a wo baaye no. Na won shede ni engina so bia because as I've told you how the case started. Na afenyuma ken shede ni engina so bia. Wodi be siki order for stay of execution no. Enti Alban Bagbin lawyer asemu a wo tre ne say the effect of this admission no sa court no judge no and a judge no ne admission we wo all tre no etre say case na ba beto yenim ni ye di kra na at all material times no to the judgment of the court no afenyuma ken no the case before the court afenyuma ken the case no it's this the court has now disclosed that it has no cause of action because the case was not formally amended. It sounds confusing, but I don't know. I hope you understand it. And let me try to break it down. Yes, our lawyers for terms. Inti send ya memeti ase ni. Osi obi ewia 1 cedi, right? Wako court. Ena okọ court no, okọ kire se obi ewia 1 cedi. Now 1 cedi na osi obi ewia no. One uni ngina so obi etre se nipa kro na ewia sa 1 cedi no. Inti asem na akwa pie mu e wo court no. New information aba. Asa new information na aba no. Ebia when your evidence and be a ni bakona eden ewia sa 1 cedi no. Now so one amend u case no. You didn't amend it. One amend it and say oh nipa korea dia oye mi we ka ho intiana me hu say oye sa dia we. Inti say judges no di case na. Na omo the old one no say one amend no the old one na edia. Oye na engina so bia. Inti say na engina so a esi de no mutumi di ruling eba. Eji say bia oba be amend case ni kire say ade we ya nipa ko yeye sisi anu me di we aba be ka ho na we a wo ye ne kra no de me pesa mo de ye no eni de me siki say wo say mo ye no eni. But Afenyoman didn't do that. He didn't amend the case and find new evidence and can. Inti say judges no judge old evidence na wo say wo mo de ye den e na old evidence ni so no sebe engineer so bi eni ho. Because senior all can no that time no 2 days na Alban Bagbin nyanye ruling nimpo and odimrika call court. Now I say in their judgments therefore the majority decisions both Dakun Asare and Asiedu JJSC only expressed their disagreements with the conclusion reached by the speaker in his response to the leader's statement. Their final orders never pronounced that the speaker's response to the leader's statement are null and void and of no effect. It was a Supreme Court judgment here. Finally, in their conclusion, asemo mo kan say wo money Alban Bagbin enyadwen over asemo a wo kan no. But wo mo ma Alban Bagbin order say yama order say de wo ye ne sesan. There is no order in that judgment. And this is Alban Bagbin's lawyer. It was the Supreme Court has not given Alban Bagbin any order. All they are saying is say decision Alban Bagbin arrive at that decision no and ye nene nyadwen. And just like everyone saying Godfrey Dame emra ni tape APA or ne ato force in case na ni tape Jakpa Mr. Jakpa ba be release ni tape no judge ne katre Godfrey Dame say Godfrey Dame ebe ya na nkatwe ho free case nim Godfrey Dame asem kan say won twen ne ho because enye order judge no edema no eye advice nti when so Alban Bagbin lawyer asem kan say judges ne nsem mo aka no it's more like omo tro omo adwen but they have not given any order to Alban Bagbin because in the first place Afenyoman court ne kra no one court say wo ko siki order say yen order Alban Bagbin say decision na wo take no wombongu nanka Afenyoman eba be amend in the case no e de no hyiemu dia nanka ne the problem ni ho nanso Afenyoman wan amend the case. And to say Dakun Asare JSC's parting words were as follows: an order declaring the interpretation placed on Article 97(1)(g) and (h) as inconsistent with the true meaning and import of Article 97(1)(g) and (h) of the 1992 Constitution. In effect, all he says is that the constitutional provisions in controversy bear the meaning he has put on them without positively saying that he has declared the speaker's decision null and void. So person say one no na adwentre judge no na adwentre of Article 97(g) and (h) no ono judge na asem a wo kan na ye no no na adwentre say ne onu hu sa article no but ono judge ne fan to speaker ne so say decision a we take no bogu on my order say the speaker's decision is null and void. Judge ne nka sa or say there is no repetition of the ex parte orders the plaintiff magically obtained contrary to all and every rule of procedure in the final orders of the court. Also, Asiedu JSC also concluded his judgment by disagreeing with Speaker when he stated thus, in my humble view, therefore, it is incorrect and unconstitutional for the first defendant to rule that the members of Parliament concerned have vacated their seat in Parliament just for the reason that they have filed nominations to contest as members of Parliament in the upcoming general elections on tickets other than those on which they were voted as members of current Parliament. It is for these reasons that I grant relief on endorsed on the plaintiff's writs. It was say his final words, however, were that he only grants relief one of the plaintiff's reliefs. None of these reliefs to declare the Speaker's response to the leader's statement null and void. I say, now, let's remember that after the Supreme Court has made a declaration in the exercise of its original jurisdiction, it is required under the provisions of Article 2, Clause 2 of the Constitution to make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. So I say second judge no, enso asema wa kan say yes. Ono nso seni Alban Bagbin ete ade na ase no, ono wonte ase sa. But ni nemu no, omo ni na wo ama order. But wo wie ye no osanso ka say e wo say Ghana 40 ase say Supreme Court ankasa no Article 2 Clause 2 amomu to me say assemba beto mu anim no mu di wie a no mo pesa assembly take effect a eje so mo ma order say ya ma order say case we ya ye di nti no asem no bogu o say Article 2 Clause 2 no eno ene ma judges no sa to me no but here it is only where such orders and directions are made and the person to whom the orders and directions are made fails to obey or carry out the terms of the order or direction made or given, which constitutes a high crime under the Constitution. So I say it is only when such orders, into Article 2 Clause 2 nitre say judges no edi assembly no mo pesa assembly take effect e was say omo siso e ka say yama order na say omo ma sa order ni wie na say obi endi assembly so a eno ne ebehu ne say nipa koro no wendi Supreme Court judges no assem so nti ebe chine for contempt. But in this case no judges no ma sa order no Inti Alban Bagbin pa on this so yentumi ngwangwa for contempt. I said there is no order saying that the MPs must be allowed in Parliament or order directing that Parliament recognize the said MPs as earlier ordered by court contained in the majority decision of the court. The order staying execution of the Speaker's ruling is now spent. So Mr. Plaintiff, tantalus on my mind. Nti uti asemo awoka ono de oye Alban Bagbin lawyer nti ase ene say judges na momu ruling and so mo ama order bia nti order judges no amma nti Alban Bagbin betumi agina so na tre say asem no kra no parliament kra no omonye ho hwe ati ase nti the order of ono person tre say sisia no ye di case na wie no the stay of execution kra no are ending. Alban Bagbin pa sa MPC or Momba Parliament because there was no order. The Supreme Court judges no omo adwen omo atre Alban Bagbin pa obefa opa wonfa e ya adwentre enye by force say osofa. So basically Alban Bagbin a lawyer adwentre awodeba quite an interesting write up awodeba. Now so for people to understand the whole thing no let me just explain it once and for all because any amaka no it is quite confusing but me reading in no me menti ase no me betrete mu mo bi ate ase right now I was say on crofoti ase say Alban Bagbin ade a wo ye no enye ne pe eno de ye de o ye I want people to understand that NDC leader ato forcing ena o raise issues a petition Alban Bagbin ena ato forcing a seeky reliefs be from Alban Bagbin say based on article say based on say ni no MPP MPs be any NDC MP baako ayesi nti wo so wo lose ni seat. It's the real case is coming from the NDC. So I want me person obi a ehye in order for you to understand. It's NDC leader no ato forcing in a raises our case no. Now, raise this case no, and Alban Bagbin eba be ready a ruling precedents based on that. And Alban Bagbin can say, oh, petition ya odi aba beto menim de no kware. Based on precedents BSC our parliament. Enya mesi wa parliament. Ene sen ya me Alban Bagbin mete Ghana mrase no. Ensemu a NDC for mo de aba no no kware. Na me igina so ama MPs no elusu omu seat. Inti enya Alban Bagbin eno sorry ye eno babema MPs elusu omu seat. NDC for any raise issue. Inti se afenyo marking epese case no ye bogwa okwa quarter e was say was seeking reliefs say sa petition ya NDC for release ye ana NDC for a petition Alban Bagbin ya Alban Bagbin eba be ready e ho nsem no e was say court no kan no ebo NDC for nsem ni gu in the first place, but afenyo marking didn't seek that in court. And that is the substantive matter. That is the main issue. But Afenyo Makin ankwanko siki sa asem no. Afenyo Makin went for a stay of execution. Stay of execution, they say Alban Bagbin ni ruling away ruling of NDC 4 case no. Courts emanen twen. Na courts enye ruling so. And na courts emretre wo madwen omonye interpretation and not a ruling by interpretation. But the main substantive case NDC 4 there no. Afenyo Makin didn't seek say court no and declare no null and void. Niembo NDC 4 petition ningu because ehon assembly free. It is here but NDC 4 petition no egua. Na the say yakop back to ground zero. Afenyo Makin didn't seek that. Send your maka no oko court so na wo kope bibia. Ade na ope no no we bisa ni na e de ni na ama. Okona okokase nipa kono 1 cedi no wi ayenti 1 cedi yanchi into 1 year. You say okay. 1 cedi no wi ayenti no onti ameka yes you okay. Ade a won fan court no court no ntumi fan ba ansem ni mu. It's the main issue raised by NDC. Afenyo Makin should have requested Senanka courts and declare no null and void. But one yes sir. Stay of execution or the to Alban Bagbin the so. It is a stay of execution no. Omo de to so omo eba beye interpretation no. And a judges nature say ruling na Alban Bagbin na embra Alban Bagbin di gina so. Edema ni readings and ni ruling no. Omo judges no omo ti asie say. Seni Alban Bagbin dwen ya wo no edema ye no ono judge no won ti asie sa. Second judge nso tre say seni Alban Bagbin so ye we no no so judge no won ti asie sa. Ena Alban Bagbin lawyer tre say Ghana mremu no say judge eye ruling bisa na judge tre adwen bisa no no pe say take effect e was say judge ne koso no ma order. But to share judges no a ruling na omo adwen tre pe no mo tre they didn't give any order. Say Alban Bagbin enu hunti NDC for petition e ba no ye declare no null and void omo ma order bia omo adwen tre no mo tre say ye de ye ti asiesi ye de ye ti asiesi na ke wo so omo ko further na nko mo ma Alban Bagbin order. They didn't give an order. Into omo ma sa order no Alban Bagbin na ni mu ebetumi atena se aka say well you didn't give me an order. Me so menti ase na me di ye ejuma sebe parliament na me bu no enye mo judges na adwen na me di bu me de me ama adwen na me di bu ti yen parliament de se ne ye ti ase nti se mo ama me order de a me mfo amo nsem so ena judges ne di asem na wie no na say stay of execution no suspended nti no ka say the last part no say the speakers or say the order staying execution of the speaker's ruling is now spent because ye di case na wie nti sa tabo na odebeto case ne odebeto ono Alban Bagbin so no sa tabo na nde etwem. And so this is the pointer Alban Bagbin so lawyer ono so title sorry nintrasi ya ono so edeba send America no quite interesting. Every single person is confused obia it will be a trim send ono so be so trim. But that's quite interesting. Muntre mwadwen comment box ni mu. Medasi.